Earlier this week, Tom Keesee's attorney filed a few motions, and because of it, a hearing was scheduled for today, which is November 6, 2025. I attended that hearing this afternoon, and I'm going to report on the outcome of that hearing. Some of you probably were there as well. It was open to the public. It was a Zoom hearing, but let's get into a couple of things. So just to remind you why this hearing was held, Tom's attorney filed a motion, and it related to a potential Brady violation, meaning when you see that, that's triggering to know that, oh, there could be an assertion, an accusation against the government or the state saying that they did not provide evidence, that they did not turn over evidence that could potentially be exculpatory to his client. Exculpatory to his client could mean that it would prove that his client is not guilty. That's what that means. So we're going to get into what that was. And when I was in the hearing, I was just taking notes. So I was typing. So I'm going to go through those as best as I can. And just to let you know, I could clearly hear Tom's attorney. I don't know what, maybe the microphone was just better at his counsel table. I could not make out Jenny Wells, the prosecutor who spoke. There was another prosecutor sitting at the table with Tom Keesee's attorney Wednesday from whatever that show was apparently with him. I know I'm being sarcastic, but she was closest to the camera and it looked like Wednesday. I mean, she had all black on, not even a suit. It was like a black shirt. She looked like Wednesday on that show. I don't watch that show because I don't like it, but you know what I'm talking about. Munsters, is it, or something? But the new one, it looked just like her. All right, let me move on. So I couldn't hear the judge either. So I was talking to other people that were listening, and so I had to plug in the holes. So I wanted to get this video out quickly, but I had to plug in some holes, and I was waiting to see if there was going to be another entry on the docket, but there hasn't been anything. And I had to look at a mainstream media or local media, their article, just to kind of plug in the holes because I could not make out what the prosecutor said. So here we go. All right. So when I entered into the hearing room on Zoom, Tom Keesee's attorney was already talking, and this is what he was saying. By the filing of the motion, I'm not saying that the government failed to abide by their obligation. Well, that he's telling the court, I'm not accusing the state of not giving me evidence. It becomes apparent he's saying that Captain Cook, one of the investigators, did not disclose evidence to the state and thereby to him, because the state can't give the defense attorney something they don't have. Okay. So he's talking about the underlying concern, and he also refers to the discovery in this case is vast and complicated. And this is what this is about, that there's an email from October 24th. So that was just 2 weeks ago, where Captain Cook of Licking County is speaking with one of the victims, and one of the victims says, "Hey, Captain Cook, here are the audio recordings I mentioned from January of 2025. So his attorney argues that begs the question now, if this email was sent in October, and the person who made these recordings or the subject of this motion appears that they had these calls since January. And the prosecutor is sitting at counsel table and she's shaking her head yes. So she appears to be in agreement with this. And so the defense attorney says there's a question as to when did Captain Cook learn of the existence of these recordings, and states clearly it was before October 24th. And so he's saying, I want to have the opportunity to examine them and to consider whether further discovery needs to be done. So when you find out there's new evidence, you can ask for an adjournment, a continuance, because you want to examine that. And then you have to consider whether this could lead to the possibility of even further evidence, something else, which could lead to the need to do more discovery, the need for more time to do it. Again, he reminds the court, I'm not saying that the government did not live up to their obligations under Brady. He says they have. So they go on and on. The defense attorney, he goes on and on talking about this these recordings. And, the judge starts talking about using the initials. They all agree to that. That is very typical when you're referring to victims, especially in SA cases, you're referring to their initials. You're not identifying their names on the record. So he's talking about what is contained in this email, allegedly what it says in these recordings, perhaps, that the victims, that apparently there's two of them, that they're talking about defamation, untruthful, which he says is important impeachment material. Could be, but we just don't know what it is yet. So again, he's talking about, he wants to get these recordings. He wants to know about these recordings. Are there other recordings? He wants to hear everything about that, which I get because, his client is going to be on trial and potentially looking at life in prison. So he argues that clearly this is worthy of further investigation. And he's talking about subpoenaing carriers to see if the person that they believe reported these calls had been in contact with the alleged victims in the indictment. So he says it's not a leap if two of the witnesses, so it's victims. So there's 4 victims. He's talking about 2 of the victims that are in communication with each other. And he says there's a likelihood that he needs to at least explore the possibility that perhaps more of them are communicating. Now, let me just stop here. When you have multiple victims in a case like this, it is not ideal that they speak to each other. So the question is for me, if they did speak to each other, when was it? If it was in January or February or March, Tom Keesee had not even been indicted yet. He wasn't indicted until April. So just because he's saying this and making a big deal and grandstanding as he did, it doesn't mean that it's going to amount to anything that's even impeachable or anything that's of concern. Jenny Wells didn't seem to be concerned. Now, clearly, she didn't learn about this until October 24th, around that time as well. However, if an investigating officer, a detective who's investigating, didn't do something they were required to do, that would be a strike against her as the extension of the investigation because she's the state. She's the representative of the state. Now, it didn't get to that point. I didn't hear the judge saying anything, and I didn't hear her getting yelled at or anything like that. But there is a concern, right? What is this going to show? Where is this going to lead? We'll find out, right? This nowhere near done. So then the defense attorney starts talking about, well, he's jammed into this position where he has to ask the court to adjourn the jury trial for the opportunity to subpoena every cell carrier and Facebook messenger and figure out if there is additional evidence. Well, I don't know if it's going to go that far or if the judge would even allow that, because if you're going to do that, what's the time parameters there? So the judge does query him on that, but he said he hadn't even started yet. And it's clear that he needs to talk to the state attorney. They need to get on the same page. Then they need to inform the judge. And so let me just say this. So when you're in court, typical, appropriate courtroom decorum is to stand when you're speaking to the court, to the judge. Tom's attorney did that, and he appears to be very comfortable in a courtroom. He has that proper courtroom decorum. He stands up. When he stands up, button your jacket. When you sit down, you unbutton it, right? So you're not tight. It's what just common practice. And as a state prosecutor, you are to stand as well. That's proper courtroom decorum. She did not. Now, I don't know if there's a local rule. There could be a local rule in that court saying that no party needs to stand. But when you have the other side standing and you know that this is a case where people are watching, I don't know, it's just me, I would have stood. And I would have stayed standing. You know why? Because he kept on getting close to her and talking. So she's having to look up at him. And that's not a position you want to be in my opinion. All right. So this is where I had to plug this in, because then the court started asking the prosecutor, Jenny Wells, about this, and she stayed sitting talking about communication. So she says that the calls were made in January before Keesee's April indictment. She said that the prosecutor's office had asked the alleged victims who alerted them to the call if there were others, and the answer was no. She really did not seem to be concerned with it. So perhaps this is a big old nothing burger. Then the judge asked Wells to contact the other victims and ask whether they were aware of any other recorded calls or communications that needed to be disclosed. The judge said that he hoped that could prevent the limit the need for the subpoenas that Tom's attorney was talking about subpoenaing in a complicated process that could delay the trial for months. I do anticipate that this in and of itself is going to delay the trial. I don't know how long it would be delayed, perhaps by a few weeks, but it could be delayed into the new year just because we're entering the holiday season. At the end of the hearing, the judge said that he would not make a final decision on whether the trial date, which is currently set for November 18th, 2025, he said that he was not going to make a final decision on whether that's going to be moved. He wanted to give the attorneys some time to see if a resolution could be reached. So there might not be a continuance, but I suspect that there will. It's just my opinion, because I think that when an attorney, a defense attorney with a case like this, that's, 32 felony counts, 13 of which are punishable by up to life, he's going to want time to address this. I feel like whatever, this is just me, in my experience, even if the prosecutor satisfied him, I think that he would at least want to inquire further and at least talk to the investigators, get all the evidence, process that. And if he feels the need to do a little bit more discovery, that is going to push out and adjourn that trial. So the next thing is the bond. All right. So before they talked about the bond, though, his attorney, Tom's attorney, talks about an alibi notice. Now, if you've been watching my channel, I've talked about that it is very difficult in cases like this when you've got now adult females who are looking back, right? They were children at the time that they were assaulted. So they're looking back, and it could be 10 plus years. So that is why the prosecutor will file the indictment with a range. That's what I used to be. If you don't know, if you're new here, I used to be a sex crimes prosecutor in Detroit. All right. So you file a date range that the acts that are contained in the indictment happen from this date through this date. And you don't give specific dates because some of these kids are kids. They don't know. Some of them, they might know the date because it happened on a birthday or a holiday, things like that. But sometimes it might be, it was in the spring because I remember my sister's birthday was near this day, whatever it was, right? However, Tom's attorney says that there are one or two counts that in the recording of the victims where they were talking about date specific. So he said at this point, it's difficult for him to file an alibi notice. An alibi notice has to have specifics. It has to say this on this date, this time, my client was not even there where the victim says this incident occurred, but they have to be specific. So right now he doesn't have the information enough to even submit an alibi notice. So there's that. So that's another issue. All right. So that's another issue. Now, again, they were told by the judge to go out and talk about that. So they're going to talk about that, probably talk about the alibi notice. And that's kind of part and parcel with those recordings. The issue of bond. There was also a motion to reduce bond. Now, you've watched me on Tom Keesee, or you watched me recently covering David E. Taylor. I talked about that extensively because of David E. Taylor's detention hearing. That's different from a bond hearing. David E. Taylor has been charged federally. Tom Keesee has been charged by the state. So there are criteria for consideration for a bond. But when it comes down to it, I mean, when I would argue these hundreds and hundreds of times over, it's always, are they a danger to the community? Are they a flight risk? And my argument, if this comes up again and I was the prosecutor here, I'd be like, no circumstances have changed. Nothing's changed. Tom has been in jail this whole time. He's been in jail for at least 6 months, almost 7. Couldn't make his $2 million bond. He's been in jail since I think it's been April 18th of this year. So his attorney stands up and he's talking about a quasi surety component. So he wouldn't have to come up with the $2 million cash, because that's where it is now. $2 million cash. Well, until today. And so, he's talking about the evidence. Well, he talks about the victims, right? He says 26 of these counts center around 2 of the witnesses who allegedly had a conversation about, if we don't get a legal case, can they come after us for defamation? And they're talking about lying and getting their stories together and getting an attorney to review their stories. Well, if this conversation occurred in January, they're not getting their stories straight for trial. Perhaps they're going through, remember that what was happening back in January and February? Since December of 2024, didn't know who was going to even pick up the case to investigate because of the contacts that the Keesees have with the government, with the attorney general. So it was getting bounced around. Brenda Keesee is a Knox County commissioner, so it couldn't be investigated by Knox County. It gets sent to the AG's office, David Yost. He doesn't want to touch it because he's friends with Gary and Brenda Keesee. It goes back to Licking County. They pick it up, but there was significant time frame with their investigation. It took a long time. So he didn't get indicted until I think it was April 21st. He was picked up on Good Friday, and then the following Wednesday, he was indicted. So if we're in the middle of April or end of April and these people are talking to each other, they could very well be talking to each other in December, in January, in March, February, March, and before he got arrested. So, here's the thing. We all know that Faith Life Church was sending out cease and desist letters and then, filing these people of that church, filing these injunctions against people. There's a lot of activity here. We don't know what they're talking about because we already know that these big organizations that claim to be churches, they strong arm people, right? And so if that's what they're talking about, that could be a possibility because they're talking about defamation because, that's what they like to do. Oh, we're going to sue you for defamation. And they're talking about getting an attorney. Well, that is wise sense to get an attorney because these victims are young people who are not, perhaps they're not savvy in the law and they're getting shuffled around. What do you think they're going to be talking about with each other? What do we do next? So I don't think that this is anything to be concerned about. The grandstanding, oh, maybe the prosecution doesn't have a slam dunk case after all. Nothing's changed. And Jenny Wells, she just sat there. She's like, but nothing's changed. There wasn't a concern. So I'm not concerned. Let's see what happens. There's no allegation that any of the charges should be dismissed. Nothing of that sort. It's really just an opportunity for his defense attorney to do some additional discovery is what it comes down to. No allegation against the prosecutor that she did anything wrong. Could there be an allegation against the investigating officer or agency? Could be. Too soon to say. Do we see that happening a lot? Oh, yes. It's in the news anytime, all the time. If you've ever watched anything, just look at Massachusetts. They're getting blown up with that, starting with the Karen Reed, Sandra Birchmore. Just go there if you want to know about any, law enforcement corruption. You'll have hours and hours of entertainment. So that is a possibility that there could be such an accusation, but I don't know. I mean, I'm just saying that it's certainly possible. So what ultimately happened was his bond was reduced from that $2 million cash bond to $1 million, but 10% surety. No, sorry, 10% cash, the rest surety. So that means he has to come up with $100,000. And Gary and Drenda are right there sitting in there, probably got the cash on them right then and there. Probably knew that there was going to be a possibility of a reduction, or they would be able to go out and get it, whatever it is. But Tom is probably getting out today, if not tomorrow. If they come up with that $100,000 cash and they can put up property as surety to support the rest of that $1 million bond, which would be $900,000, he's out. He's already surrendered his passport and license. He would have to go to pretrial services to get set up with that GPS. He has to pay for that. It's about $300 a month, something like that. And I anticipate, just based on what I saw, even though it's not record evidence yet, I anticipate that the judge will likely continue this jury trial so that his defense attorney can do a bit more discovery. So that's where we are. I will provide you with an update. As soon as I hear anything, if there's an entry on the docket tomorrow, I'll do a quick update. But my intention, I have an interview on Saturday with somebody. We're going to be talking about Jeremiah Johnson. I've got other people I'm talking to, a lot of stuff in the works. And of course, I want to do a deep dive on the Daystar video after we have seen other videos that have come out through the FOIA request. That was done by Jonathan and Susie Lamb and exclusively given to Julie Royce. So I will be doing that. I did a quick video the other day on my initial thoughts, and I missed the fact that there was the video and it showed Josh Brown in the detective's office. And I think I might have just probably looked away and I didn't see it. But when I look back, he's there. So there will be a video. Question is there a video of Joni Lamb? Did she ever go in? Did she ever go in and talk to the detectives? I can't see her as being somebody that would cooperate because she has to be Joni in charge. But we'll see. In any event, I hope this was helpful. I look forward to hearing what you have to say. I'm sure you're going to have some questions. I tried to address stuff that I anticipate you're going to ask. I know that there is some lawyer speak here if you need clarification on terms I'm using, but bottom line is likely going to get out today, if not tomorrow. More likely than not, the jury trial will be adjourned from November 18th to another date. I anticipate it would likely get moved into the new year, probably January, February. I do plan on going, so that doesn't change. It's just going to get moved, and I will be there for that. And keep talking about this, because the last thing we want is people to get discouraged. Don't get discouraged. This is going to happen. Keep talking about this case. Keep on encouraging people to come forward, because there are more victims out there. And maybe this is an opportunity for more victims to come forward. Maybe they're on the fence and maybe, come out. It's an opportunity for more victims to come out, because we know you're out there. I can't talk about it, but I know that there's more. So I'll leave it there and I'll see you soon. And I look forward to hearing from you in the comments.